Good morning. My name is Malcolm Neekirk. Welcome to Fretton's 6th coffee break briefing of 2023. I'll give you a quick reminder now to try out the retention of title website tool I showed you a couple of months ago. It's on our website, so why not scribble down a quick note to yourself to have a look at it at the end of this morning's presentation. So I'm going to be talking about agreeing creditors' claims in this presentation. This is part 2 of a two-part topic. Part 1 was last month, and the recording for that and a written summary are both on our website. So if you want to go back and look at the points that we covered in part 1 of this session, that is all now available. As with part 1, in part 2 I will be looking mostly at voluntary liquidations. A lot of the points that I'll be bringing up are of wider relevance to other types of procedure as well, but I don't want to try and cover all of them in one session, because otherwise we get deeply into compare and contrast territory, and I'm not sure that's going to be terribly exciting for any of us. So in part 1, the two topics that we covered were stopping litigation, the insolvency moratorium that comes into force at the start of a liquidation, and indeed almost every formal insolvency procedure. And secondly, we were looking at valuing creditors' claims for voting purposes. In part 2, I'm going to be looking at valuing creditors' claims for dividends, and arising out of that, I'll be looking at dealing with contested claims and creditors' appeals against your decision. And I will also be talking about disclaimers. Disclaimer might not be an obvious topic to include under this general heading, but disclaimer can be a very useful way of bringing an open-ended liability to a close and having it quantified and allowing you to admit it as a claim in the liquidation. So that'll be the final point I'll be talking about in this presentation. So before we get stuck into the detail in depth, some general points. First of all, some debts are not provable and are not eligible for a dividend at all. I'm not going to say any more about those. I may well talk about that on a future coffee break briefing on another date. Second thing is, you will no doubt be familiar with the small debts rule, which is that below the £1,000 threshold, you don't have to apply the full formality of the usual rules for assessing creditors' claims. Strictly speaking, the small debts rule, when you choose to apply it, will apply only for proving for dividends. Next point there is, if it's a member's voluntary liquidation you're dealing with, creditors don't have to submit proofs of debt in those. You can ask for them if you need them. And proofs don't have to be on a proof of debt form. Now, it's convenient to use the standard form because that contains everything that should be included in a proof of debt form, but if you have enough information without a formal proof of debt form, then you don't have to ask for the information to be duplicated on the form. And the final point on this slide is that a creditor can withdraw their proof at any time. If they decide they no longer wish to participate in the liquidation, they can do so. And they also have the right at any time to ask you to allow them to vary their proof of debt. And if you don't agree it, they would have a right to go to court about it. So it's one of those things where if they've got a reasonable argument for saying why they want to vary the proof, then you will of course allow them to do so. The procedure for agreeing creditors' claims, there's a statutory procedure, and that is triggered by your declaration of a dividend. There's no need no requirement to agree creditors' claims until you have a dividend to pay, and in fact you wouldn't normally spend any time assessing creditors' claims for dividend until you are sure that there was a dividend available to pay to them. So when you're going to declare a dividend, you have to gazette a notice, and if there are any creditors who have then not proved, you have to give notice to them. The notices that you issue at that time have to set an ultimatum, a last date for creditors to let you have their proof of debt, and you've got to give them at least 21 days for doing that. That last date for the creditors to get their proofs of debt in also triggers an ultimatum for you, in that you then have 14 days from that last date for proving to either admit the claims in whole or part, or to reject them, or to provide for them. In other words, that's your ultimatum for making your decision on the claims. If you have claims that are difficult and complicated even at this stage, and you are unable to agree a final figure for them, that's when you should be providing for a claim of that sort, so that you have funds set aside to allow you to pay it in full if you need to. When it comes to agreeing claims, there are three things that you need to decide. Firstly, you have to decide on liability, whether the creditor is actually a creditor at all. Secondly, you have to decide on quantum, how much is this creditor owed? And the third thing you have to decide is the priority of the debt. Is this creditor only an ordinary unsecured creditor, or do they have a higher claim in the liquidation, perhaps as a preferential creditor or through some security? So looking first at liability, yes, you have the choice to admit or reject the proof in whole or part. If you are going to reject any of it, then you have to give written reasons to the creditor, and those written reasons may form the basis for an appeal by the creditor in the future. So it's important to take a degree of care in putting those together. Secondly, if you are going to admit the claim, even in part, then you have to agree the value that it is going to have for payment of a dividend. And if it's not clear what the value should be, if there's any sort of dispute or uncertainty about it, then you have to estimate a value for it. And if you receive new information that should change the estimate, then you should take that new information into account and revise the estimate. The third thing you have to decide is what class the claim falls into, what its priority is. Is it just an ordinary unsecured claim, or does it have higher priority than that? And for each of these points, you are entitled to ask the creditor to produce evidence to you that you need to decide what their claim is. Looking at some special cases, first of all, secured creditors. As you know, secured creditors can prove only for the unsecured element of their debt. That's all that they will get paid a dividend on. So when they put their proof of debt in, they have to put an estimated value of their security on the proof of debt. Once they've done that, they can change the value that they have given to their security, but they would need to get agreement from either you or the court. Now, I'm sure that you would allow them to revalue their security if it's reasonable for them to do so, if they can show why they need the revised value. And there are a couple of tools that you've got if you think that the secured creditor has put an artificially low value on their security, if you think that they're proving more in their unsecured part of the claim than they're justified to. First of those tools is that you can sorry, I'll talk about that in a minute. There's a couple of other things I need to talk about first. One is if they actually sell the property, then they have to substitute the actual price that they get for it, the actual realization for their estimate. That happens automatically, and they have got the right to surrender their security. And if they do surrender their security, then they become an unsecured creditor. Seems an odd thing for a secured creditor to do, but there are circumstances in which the security might actually be a burden, and they may think that commercially it makes more sense to get rid of that burden and then have an enhanced claim for a dividend in the liquidation. And if they don't disclose their security in the proof of debt, if they forget to mention it, they have got the right to correct it if it's an honest mistake, and you would normally allow them to do that, I think. This is where I was jumping ahead, and I was talking about what options you've got if you think that the creditor has undervalued their security in their proof of debt. First option that you have got is you can say to them that you want to redeem the security for that figure. So they say that their security, their mortgage is worth only £1,000. Fine, you can give them 28 days notice that you will pay them £1,000, and they will then release their security. They've got the right then to ask to revalue their security, which they may well do. The other right that you have got in a case like that is you can insist that the creditor must sell the property to test genuinely whether their estimate of its value is legitimate or not. Another special case is rent and other periodical payments. Under the rules, strictly speaking, the claim in the liquidation is the unpaid rent accruing to the start of the liquidation. But landlords, other creditors entitled to periodical payments are also allowed to add to their claim the post-liquidation payments as and when they become overdue for payment. So that means if the rented premises are empty, nobody's paying the rent, that means quarter by quarter the landlord can increase their claim by the unpaid quarter's rent. And that's undesirable because it's an open-ended commitment in the liquidation, and it could result in you having to keep the liquidation open until that commitment comes to an end. Very often the landlord will bring matters to a head by forfeiting the lease themselves, or you may well be able to agree a surrender of the lease as a way of bringing the liability to an end. If neither of those are viable, then you may well find yourself looking at disclaimer as a way of bringing the rent to an end, because ending the lease and ending this continual accrual of value to the landlord's claim can be a very useful thing to do. There are rules about debts which are claimed in a foreign currency, and rules about where there has been a trade discount traditionally applied to the creditor's account. I'm not going to talk about those in any detail. Similarly, there are rules about interest and what rate of interest can be charged, statutory interest or contractual interest, and in what circumstances. I won't say any more about that here. And also where there are mutual dealings where you have creditor and the company both owe each other money, then the cross claims are netted off and the net balance is how much the creditor can claim. It's not always straightforward to apply the set-off rule in the liquidation. So again, I won't go into that in any more detail. And another rule which is simple in concept but can be complicated to apply is the rule against double proof, which is saying that as liquidator you cannot pay out more than once for a dividend for the same debt. In other words, imagine the situation where the bank are proving in the liquidation for a £50,000 overdraft that the company had got, and imagine that the director of the company had given a personal guarantee for that overdraft. In that case, you would, in most cases, accept the bank's claim for £50,000, but not the director's claim. The director, of course, if they pay the £50,000 they owe under the guarantee, they would then be entitled to reimbursement of that from the company. So they would then be allowed to make a claim themselves. But you wouldn't have both the guarantor and the bank both proving at the same time for the same debt. But as they'll, I think, cover that and the rule of, and set off in future coffee break briefings. Move on now to look at contested claims. And there are three ways that a claim might be contested. The first one is if there is litigation which is allowed to continue despite the moratorium that normally applies in a liquidation and other types of insolvency procedure. That litigation is most likely to have started pre-liquidation. And I won't say any more about that because this is a topic that I did cover in part one of this presentation. The second way that a claim could be contested is a court application for directions. And that could be either you or the creditor who apply to court for directions. The courts normally will expect the liquidator to do the job of agreeing claims. That's what you've been appointed to do. So the courts are reluctant to get involved in claims for directions which are about agreeing a creditor's claim unless there is a good reason for doing so. One good reason for doing so might be if it was an issue that affects several creditors, so it's effectively something of a class action, and the ruling that the court is being asked to make will be of general importance. Again, if it's a point of law that is really the issue in contention, again, it may be appropriate to go to court for directions in a case like that as well. The third way that a claim might be contested would be if the creditor themselves were to appeal against the decision that you have made. And this is the next point that I will be talking about under the heading of creditors' appeals. And this is usually the most appropriate way of resolving contested claims. I do actually rather like this procedure. It's been designed to encourage pragmatism and to encourage creditors to look to cut a deal rather than going to court about this. I think I can only think of one case that I've been involved in where this has actually gone to court. It's usually settled. First thing that helps is the short period that the creditor has got for lodging the appeal. They've got only 21 days to do so. Court has a general discretion to extend time limits, but they wouldn't extend this by very much. So it's normally going to be pretty obvious, I think, when you're rejecting a creditor's claim, if the creditor is likely to be going to lodge an appeal. There'll probably be enough indication before then as to which way it's going. The second rule about this that I do like is that the liquidator is not normally going to be liable for the creditor's legal costs. So even if the creditor manages to make their case out and they win the appeal, it's only in unusual circumstances that they are going to be able to ask for and get a costs order against the liquidator personally. They may get an order to say that their costs are payable as an expense of the liquidation. But all that really means is that the funds available for the creditors as a whole will be depleted by your legal costs and the creditor's legal costs. And the fact that that is going to be a likely consequence of an appeal does actually discourage a lot of creditors from wanting to pursue it, because they can see that the benefit that they may gain from winning the appeal may well be outweighed by the diminution in the dividend they get, because the costs will have to be paid before the dividend is paid. Third things I quite like about creditors' appeals is that they do come quite late in the day, towards the end of the liquidation, and by then whatever it is that the creditor was cross about, there's a good chance that they will have calmed down and mellowed over the months, if not years, that have gone by since their initial fury about the situation. And the fourth reason why these appeals are usually settled rather than going to court is because the actual amount at stake may not be very much. It may be that the amount that's in issue is a difference of £30,000 on the size of the debt that the creditor is claiming, for example. But it then might be that in actual fact, even if the liquidator were to win and were to get their £30,000, they would be paid only, let's say, a 10p dividend on it. So it may be only £3,000 that they can benefit from anyway. Go back to the point that I made earlier to say that as liquidator, you have to give your reasons in writing when you reject a claim in whole or in part. And it is that rejection that triggers the creditor's rights to appeal. So it does make it important to make sure that the reasons that you are giving to reject the claim are legitimate reasons, and you may want to get a lawyer involved in helping you to prepare them and actually advising you how to deal with the claim. Move on from there to talk about disclaimer. And as I said at the beginning, disclaimer might not seem an obvious subject to be talked about in the context of creditors' claims. I mean, disclaimer is essentially getting rid of onerous property, which can be any unprofitable contract or property that's hard to sell, or anything that's costing you money to keep it, or may require you to do something that's difficult in order to comply with terms and conditions. The procedure for disclaimer is actually quite simple and straightforward. There is a notice that you have to give. The rules say what has to be in the notice, and once you have filled in the notice and signed it, you then need to give it to interested parties. That is all it takes to disclaim. The creditor has got the right to force your hand on this. So the creditor, very often the landlord, has got the right to give you a written notice asking you to decide whether you are going to disclaim or not. And from the date of that notice, you then have 28 days to decide whether you're going to disclaim. Once those 28 days have gone by, if you have not then disclaimed, you lose the right to do so. And if that happens, it's going to be important to put a note on the file to make sure that you don't accidentally try to revive the right to disclaim at some point in the future. The effect of the disclaimer is it brings to an end whatever interest the company had in that property. So if the company was a tenant under a lease, effectively it brings the lease to an end, but it does not affect the rights or liabilities of any other party. So if the bank held a mortgage on that lease, they will still have their mortgage, they will still be able to repossess if that's what they were entitled to do. Although you have disclaimed the company's obligation to pay the rent, the guarantor will still be responsible for paying the rent, so it doesn't get them off the hook. Interested parties such as the landlord can apply for a vesting order. And now you've disclaimed the property, it no longer exists. You've dumped the obligation to pay quarterly rent on in the future for the next 7 years or whatever it may be. But that claim is replaced by a claim for damages for breach of contract, because essentially by ripping up the lease in this way, that is effectively a breach of contract, and the landlord would be entitled to claim financial compensation for you doing that. That claim that the landlord has will be an unliquidated claim for damages for breach of contract, and that means that you will now have to assess and admit or reject that claim that the landlord is making. That can be a really useful way of replacing this future commitment to pay rent, this open-ended commitment, with a single claim in the liquidation. You will then have to assess the value of that claim and agree it with the creditor. That can be another difficult and complicated issue depending upon how much is at stake, but disclaimer can be a really useful way of dealing with those sorts of future payments. So with that, I have covered all of the points that I wanted to cover this morning, and if anyone has any questions, then please do ask them now. I'll just keep the question box open for a minute or two in case anybody would like to ask. And I did say at the outset that I would give you a bit of information about the CESCA courses and conferences that you might be interested in. Before then, there is our next coffee break briefing on the 7th of August. And at that one, I will be talking about post-appointment supplies. And there's some new provisions, relatively new, been added to the Insolvency Act that limit the right of suppliers to cut off their supplies to a company that has gone into a formal insolvency procedure, typically administration. And that's what we're talking about when you see the reference there to ipso facto clauses. That's what I'll be talking about in October. In September, there's a 2-day CESCA conference at Reading University. It's always a very good event. They've got some excellent speakers there, and I'll be doing a presentation, I think, on insolvent partnerships. So if you haven't yet booked onto the CESCA conference in early September, strongly recommend that you do so as well. and also recommend the Sesca seminar on the 5th of October at Denby's Wine Estate. Again, there's a good lineup of speakers for that. It should be a good day out. And with that, I will say thank you all very much indeed, and I will see you again 7th of August for the next coffee break briefing, if not before. So thank you and goodbye.